I just want to suggest that we're speaking about House Bill 427 and not the compact itself. So as you bring your testimony, that hearing is coming and you will all have a great opportunity to speak. So if you start to wander from the purpose of this bill, I may interrupt you, and I'm not doing that to be rude. I'm just doing that to keep you on the bill. So with that, Representative Brown, would you like to open on your bill?
Mr. Chairman, ladies and gentlemen of the committee, I am Representative Bob Brown from House District 13, BROWN, which represents western Sanders County and part of Flathead County. HB 427, an act providing for the defense of water rights throughout the state of Montana from competing claims to be filed in the legislature. Legislature does not pass the Confederated Salish and Kootenai Tribes Water Rights Compact, providing an appropriation for processing water rights claims filed on or off the Flathead Indian reservations, expanding the duties of the Office of the Public Defender to include providing counsel to certain water rights claimants on or off the Flathead Indian Reservation, creating accounts and providing funds to the Department of Natural Resources and Conservation, the Water Court, and the Office of the Public Defenders. You know, I'm going to approach this I guess in a little bit different manner than what you maybe would expect. Everywhere I go, I'm going to first tell you that I am not a water compact expert. Every room I go to seems to be filled with experts, and I can't seem to get very many of those to agree. So, you know, I'm not going to argue about the compact or what it states. What this bill really is about to me is about protecting the rights of Montana citizens when they are under attack by you know, in this, we have heard a threat of 10,000 claims that are going to be filed against our Montana citizens. You know, I believe that is that's kind of an obscure number, because I don't believe it's going to be 10,000. I believe it's going to be something less than that. If it was going to be more than 10,000 cases, I believe that we would have heard a number larger than 10,000 cases. But I believe that number is just completely obscure. So really, I'm going to approach this from you know, a working man's point of view. You know, and look around at your friends and neighbors. How many of them can afford to be just dragged into a court case because they have done absolutely nothing for the land and the water right they've lived on for generations? Many of these people are small farmers and irrigators. That's their livelihood. That is how they survive, and they have been doing that for generations. They can't afford to be getting pulled into court, and especially on such a mass scale. You know, I had one lady that I did talk with. She said, you know, it's hard for her to pay to get her kids to the doctor when they have a problem. They have enough water to grow enough hay to feed the cows that they grow. That these are people that to work to live and live to work. That's what their life is. And so you know, I'm going to be fairly brief here, but it's really, to me, it's about protecting the rights of Montana citizens and the right that they have and they have always had. For generations, they have had those rights, and through no fault of their own, they are going to be dragged into court. So thank you.
Thank you, Representative Brown. Proponents to House Bill 427. Proponents?
I'm Verdell Jackson from Kalispell. Termed out January 5th. Was in the legislature for 16 years.
You want to spell your last name, Senator Jackson, for us, please?
For you, Representative Bennett, I will. Jackson. There are different ways to spell Jackson, so thank you. Well, good morning, Chairman Bennett, members of the committee. I passed that out so that I could make mine shorter. And I have studied the compact for 2 years. I've read it several times. I have to admit, though, I got the last 70 pages and in January 30th, so I couldn't do that. But I'm going to, reason I passed that out, I know that Chairman Bennett's going to gavel me out here in a minute. The purpose of the bill is, as the sponsor said, it's to alleviate the fear that we have out there. And I get a lot of phone calls where people are in tears, really frustrated over it. And some have even told me they're going to sell their property and move out of Montana. But, I don't see the 10,000 claims as that big a problem. What I see as the major problem is the breach of Montana sovereignty, and I have that in my paper. The general public has been inundated by a $2 million media blitz, which I've never seen before. And that's another reason for this bill. And it starts out grounded in the Constitution. And when they say that, I always think grinding the Constitution, because none of that's true. And I've never seen that type of thing done in 16 years I've been involved with the legislature. The other thing is that the general public is being disarmed by the $1 million statewide media campaign, and I do know that a lot of special deals have been made to get proponents for this compact. And I was approached and said, that's when I was Senator Jackson, would you support the compact if we remove the off-reservation water rights? And that was being discussed at one time, and I said no. And they said, well, why? Why wouldn't you do that? And I said, it's bad for Montana. That's the reason I wouldn't do it. But it does solve your problem, because you are mainly against the off-reservation water rights. And I said, well, my integrity is not for sale.
So
I don't vote for anything that's
Senator
not
Jackson,
bad for
so
Montana.
Can you bring that back to the bill, please?
I am. I'm talking about why this bill's necessary, because all of this is going on. And the other thing that's going on that I think is a violation of balance of power is that the governor and the attorney general are making phone calls to try to get people like county commissioners, legislators, to support the compact. Well, I know that that's a violation of balance of power.
Mr. Chair.
Yeah, you're going to get objected to, Senator Jackson. So if you can
want
bring
me to focus more?
Yeah, I want you to focus more. Yes, sir.
Okay.
Thank you. If you can bring out some aspects of this bill and point to the bill and let me know that, and the committee know, that'd be great. Thanks.
Okay. The reason I think there's going to be some opposition to the bill, but I want to tell you about a document that you might want to pick up. It's called Basic Montana Water Law. It was last revised by Judge Lobel. And the reason that this bill is necessary is this. The definition of property rights is, it says, water rights in Montana are property rights. They are afforded the protection of the United States and Montana Constitution, just like any other property right. Water rights have value, and water users cannot be deprived of their property without due process of law. And I'll read one more short thing out of this. On July 1, 1973, the Montana Water Use Act became effective. The act did not alter basic water rights concepts, but the procedure for acquiring and changing water rights became an administrative process overseen by the Montana Department of Natural Resources. The legislators dealing with water should kind of pick this up. It's on the internet. Okay, with your patience, Chairman Bennett, I would like to talk about another aspect of this that has people afraid, and I'll conclude with this. It's called litigation instead of adjudication, and I have gone through the personal process of getting water rights, and I know what's involved, and it has been extremely distorted to the general public. Judge Lovell told me that 95% of the people that go through adjudication do the work themselves. 5% would hire a lawyer, and in my case, I did all the work myself. And the Montana Water Court's very capable of doing the work that this bill would put on them. And this bill puts a little bit of money in there to basically help these irrigators across the whole state that could be impacted by this. And I have enough faith in the Montana Water Court that I think that they can do the job. And I put money into, or there's money in 3 places in the bill. One, the biggest amount of money, if you'll notice, the $13 million, if you look at the bill, goes into Department of Natural Resources because they do the grunt work in adjudication. And then there's a little bit of money put in the Montana Water Court, and then there's $5 million put in there to help individuals, and those individuals are held through the Legal Defense Fund, and they would have to hire lawyers that were experts in order to provide that assistance. So they don't actually hire a lawyer, but it's done through the Legal Defense Fund, and they're the ones that pay the lawyer, and they would get the appropriate lawyers needed to basically do the work. Thank you.
Thank you, Senator Jackson. Further proponents?
Good morning, Chairman Bennett, members of the committee. My name is Catherine Vandemore, Catherine with a C, C-A-T-H-E-R-I-N-E, Vandemore, V-A-N-D-E-M-O-E-R. And I live in St. Ignatius, Montana. I am the chairman of the board of the Montana Land and Water Alliance. As a professional in the field of federal reserved water rights, I rise in support of House Bill 427, which I view as a bill which does 2 essential things. The first is it gives the Montana legislature an opportunity to fully evaluate the merits or lack thereof of the proposed CSKT compact without the threat of 10,000 claims being filed. And secondly, because it will have the effect of protecting the citizens of Montana should the compact fail and the tribes follow up on the threat. While we can and will legitimately demonstrate beyond a shadow of a doubt that this threat is factually unfounded from a reading of treaties and so forth, it actually has been used to divide Montanans, where eastern Montana goes against western Montana, where neighbor goes against neighbor. It's been a very divisive, unfortunate event that has happened to Montana, and it really clouds the judgment which we all must exercise right now as we look at this compact. Basically, what has happened is fear out of intimidation, as a result of intimidation, has resulted. You may or may not know that this threat of litigation is a common threat used by the federal government against states. It's happened all over the western United States. Because the federal government does not have to pay fines, filing fees, it has filed thousands and thousands of claims across the West. And the common result is that the federal government loses. In Idaho, where 6,700 claims were filed by the government, 2,000 of those on behalf of the tribes, only 7 were approved. 6,700 and only 7 were approved. There is specific information about the Nez Perce settlement that you need to be aware of. They were awarded, well, they really weren't awarded, the water right off reservation for 200 in-stream flows had a basis in the Nez Perce Treaty, where the government actually reserved off-reservation springs and fountains. But secondly, those 200 streams had a minimal flow. The title is held by the Idaho Department of Water Resources. The priority date is 2007, and they are subordinate to every existing use, including some future uses. So there's been a lot of fear generated about that. And basically, just because claims are filed doesn't mean they're going to win. Now, I believe the CSKT. If they file these claims, then House Bill 427 will provide the Montana Water Court, the DNRC, and the citizens the tools to properly review and evaluate the claims. It is the tribe that will have the burden of proof as they challenge already decreed water rights. And I just want to recall to mind what Wyoming did when the Environmental Protection Agency basically ruled that the city of Riverton was on the reservation. Wyoming stood up immediately, and although the tribes backed down, the state of Wyoming stood up for them. It's a particular concern for me because I worked on the Wind River Reservation, so I know what happened there, and I couldn't believe it. But anyway, the threat, although we believe unfounded, is real. I just wanted to let you know that it's not just this threat of litigation that is underway. The CSKT in February 2014 filed a very aggressive lawsuit against citizens on the reservation, going after land title as well. So in the compact and the land title, recent court proceedings have indicated that even if the compact is passed, this lawsuit's going forward. So there are lots of theories regarding that, but not relevant right now. The aggressive action, though, is not limited to water, but to land title. I want to ask you, please, to protect Montana, give yourself some breathing room so you can really look at this compact, stand up for all your citizens, pass House Bill 427. Thank you for your consideration, and thank you for your service to Montana. And I'd like to hand out copies of the tribe's federal lawsuit. Thank you.
Thank you. Further proponents, and I know this is a very passionate subject, and there's lots of ways we can go here, but I'm given a little bit of latitude, but we don't want to be here all night. So if we can stick to the merits of the bill, that would be great. Further proponents?
Thank you, Chairman Bennett and members of the committee. My name is Jerry O'Neill, O''Neil. And I just passed out a brochure presentation. And in the presentation includes the Treaty of Hellgate, and it includes back farther a United States Department of Interior letter on December 21st, 2007 to James Steele, Chairman of the Confederated Salish and Kootenai Tribe. And then farther back it has the findings of fact, conclusions of law, and writ of mandate that Judge C.B. McNeil issued in the case of Western Montana Water Users versus Mission Irrigation District. The object of the handout is to point out that there's this as far as I'm concerned, it just concerns, this is just about the water rights of the irrigators on the reservation, how they are being, the compact is attempting to take them away, and if the compact fails to go through, I believe based upon what's happened in the compact, the tribes are also going to go after those water rights. And this hopefully will show that those water rights are defensible, and that the threat that it's going to cost $1 billion to protect our water rights is hopefully overblown, and that these water rights are defensible. The only other issue I have, or I intend to bring forth for you today, is the water right. The tribes are going after the in-stream and recreation water rights in joint with the Montana Fish, Wildlife, and Parks in the Flathead River, in the South Fork, Middle Fork, and I believe the North Fork and the main stem. And if you have a water right, even in conjunction with somebody else, then you have a right to defend that water right. So I am guessing that if the compact does not pass, the tribes are still going to go after that water right of the in-stream flow. And if they have that water right for in-stream flow, if we can't defend against that, I think that they're going to have a right to say what size of motors we have in our jet boats on Flathead River, or how many fishing lures we can use. According to the language of the compact, it seems they would have that. And it's maybe it's dubious, maybe they won't have that right. But I think that's an issue that will quite likely to go all the way to the U.S. Supreme Court. And I think that we need the funding here in order to defend our citizens' rights. Whether the compact goes through or the compact doesn't go through, we're going to need to protect our rights. Thank you.
Thank you. Further proponents?
Chairman Bennett and members of the committee, my name's George Hudson from Kalispell, Hudson, spelling the last name. I retired here to Montana 4 years ago, and I probably am in a position where I could buy a house, you know, and I haven't done that because I heard about this water compact coming up and how it may affect property values, how it may affect property. And I see this bill here in front of us, HB 427, which I'm supporting because I think it's a good bill. And I look at my own history here and what's happening with all the rest of the people in Montana, and we are being coerced, it seems to me, to vote for a water compact that's going to give away 70% of the water that we have now. And for what? It's a fear factor. It's simply a fear factor. They're threatening us with lawsuits. They're going to sue us for the water rights and the water that we've always had that came with the land. All I can say is that's a empty threat. I say bring it on. Let's defeat the water compact and let's vote for HB 427 and let the chips fall where they may. Thank you.
Further proponents?
Good morning, Chairman Bennett and committee members. Thank you for the opportunity to testify today. My name is Terry Backs, B-A-C-K-S, and that's Terry with a Y, and I'm here from St. Ignatius, Montana today. I'm here to support Representative Brown's House Bill 427. I believe legislators should have a good alternative to accepting the CSKT compact, and HB 427 provides that. This bill helps diffuse the tribe's coercive threat of 10,000 claims and will ensure that Montana has the resources necessary to process and review water claims should the compact fail and the CSKT follow through with their threats, which we have no doubt they will. It is a contingency plan, a safety net for the state of Montana, and I can't see why you would not want to have the resources set aside should this threat be followed through with. I urge you to support this bill. I thank you very much for your time. I have a petition signed by about 250 people who could not be here today that support this bill. Who would I hand that out to?
Just pass it up, Ms. Bax, and we'll get it to the secretary for the record. Are there individual copies, Representative Laszloffy? Oh, okay. It's just one petition. Okay. Further proponents?
Thank you, Mr. Chairman and members of the committee. For the record, Abigail St. Lawrence, that's spelled S-T-L-A-W-R-E-N-C-E. I'm here on behalf of the Flathead Joint Board of Control, which is the governing body that governs over the irrigation over 90% of the irrigated acres within the reservation. I've also been asked to speak on behalf of the Rocky Mountain Stock Growers Association, which is an association of irrigators and ranchers in the Upper Clark Fork area, and Dixon Mellons, which is an agricultural operator on the reservation. Mr. Chairman, members of the committee, as the chairman has pointed out, this bill is not about the compact. Rather, it is about a contingency plan, which is always a smart idea. The funds made available through HB 427 could supplement current DNRC and water court budgets to handle any additional workload should the compact not be passed. HB 427 also provides protections for existing water users so they don't have to expend their own funds to deal with any threats of litigation or to object to any additional water right claims that may be filed. I would make one suggestion in HB 427, and it deals specifically with Section 1, subsection 3 of the bill, and also the responsibilities laid out for this new entity of the water defender in Section 4. And that suggestion would be that perhaps we consider moving this to a civil division within the Attorney General's office. I would also suggest that if that suggestion is considered, that the AG be required to apply and assert all defenses and objections on behalf of state-based water users, such that the AG cannot waive those arguments due to inattention or political concerns. Mr. Chairman, members of the committee, HB 427 is a good contingency plan for addressing any threat of litigation that may result should the compact not pass. I would urge a do pass recommendation on HB 427. Thank you.
Thank you. Further proponents? Proponents? Seeing none, are there opponents to House Bill 427?
Mr. Chairman, members of the committee, my name is Krista Lee Evans, and I'm here today on behalf of the Senior Water Rights Coalition, which is made up of farmers, ranchers, irrigators, and hydro interests from across the state of Montana, as well as AGI, which is the Association of Gallatin Agricultural Irrigators. And I'll respect the chairman's wishes and not go off of the bill and spend time rebutting some of the comments that were made by the proponents in relationship to the compact. However, I think for the committee to fully understand this bill, it's important to understand the basic underlying issue, and that is claims in the water court and how those function and how those work. Under Montana water law, all claimants had the opportunity to file their state-based claims in the water court. Federal and tribal reserved water rights were not required to do that pending negotiations, okay? The CSKT tribe is the last remaining compact. All other federal and tribal reserved water rights were settled through compacts, okay? So the tribe really has two options. They either settle through the compact or they're required by Montana law to file their claims in front of the water court in order to protect what they believe is a legal interest in water rights. Whether you agree with that or not, under the McCarran Amendment, which is a federal law amendment, all claimants have to be treated equally, whether they be federal, whether they be tribal, whether they be state citizens, okay? So if the compact does fail and the tribe files their claims in the water court, another critical piece to fully understand is that those claims will be treated as prima facie, which means they are treated as being 100% correct. This is different than in other courts and is pursuant to our state law. And again, in order to be McCarran Amendment compliant and keep water law issues in our Montana courts, we have to treat all claimants alike. So the claim made by the proponents that the tribe would have to prove their use is wrong, because they don't. Montana law has said you don't have to. My irrigators didn't have to. It was up to other irrigators to object and to show that the claim was wrong or had defects. That same thing would apply with the tribal claims, okay? It would be our responsibility as state-based water users to prove that there's a defect in their claim. The other important element to understand is that those claims would most likely have a priority date of 1855 or time immemorial. Okay? So that's the water court basis that we are now putting the public defender in. Okay? So I think that's important to mention. Additionally, in front of the water court has issued an order that if you are incorporated, which a lot of my agriculture folks are for tax purposes, if you are incorporated, you cannot represent yourself. You must hire an attorney. The water court has ruled. That's the way it is. Okay? So that's kind of the playing field that we're in if the claims or when the claims are filed. So let's talk about specifically what is in this bill. So in this bill, the proposal is to have the state public defender defend my people's private property rights. Doesn't happen in any other situation in the state. And I would question, no offense to the public defender, what knowledge and understanding do they have of an incredibly complex area of Montana law? And is it appropriate for the legislature to expect me to let them or have them protect my property interest when they have no experience in this arena? Secondly, how many attorneys is the public defender's office going to have to hire in order to avoid conflicts of interest among the attorneys? Just on one case, you could have 10 different objectors. So the tribe files one claim. They don't file claims against existing water rights. They file a claim on a stream saying, I believe I have this amount of in-stream flow dated this priority date. There could be 10 existing water users who object to that. That's 10 different attorneys. Where are all those attorneys going to come from? Additionally, these are incredibly complex cases. Is the Office of Public Defender also going to hire hydrologists, engineers, biologists, people who understand water necessary for in-stream flow? Who's going to pay for that? Additionally, the funding that's in here. Okay, so here's real-time numbers. The Montana Water Court at the Water Policy Interim Committee, this interim, in order to finish the last 7 decrees so that they're enforceable. These aren't final decrees, but into enforceable decrees. 7 decrees, it'll take $14.6 million for 7. It's estimated that if the tribe files their claims, that will open up at least 35 basins. So let's take 14, if it's 14.6 for 7, we'll just do some rough math. 14.6 for 7 decrees. That amounts to $73 million for 35 basins. And they got 2 in this bill. Additionally, in Section 4 of the bill, it puts a burden on the Public Defender's Office to defend state-based water right users. Granted, it gives the Defender's Office $5 million. But guess what? The responsibility in Section 4 doesn't go away if the money runs out. The public defender is going to have to represent state water right owners, even if they don't have the money to do so. In all due respect to Representative Brown, this is not well thought out. It puts an incredible cost burden on the state, and it puts state-based water users at a horrible position. Please oppose House Bill 427. Thank you.
Thank you. Further opponents?
Good morning. My name is Hertha Lund. First name is Hertha, last name Lund. I'm an attorney who's been working on behalf of agriculture and doing water rights for more than 20 years. So I've spent a lot of my practice on the property interests in Western water rights. And today I'm here representing the Common Sense Citizens for the CSKT Compact. It's a group of farmers and ranchers on the Flathead Reservation who support the compact. And I won't go through some of the issues that were raised earlier either, I'll keep it on the bill, but you should know that the whereas clauses to this bill has many inaccuracy and you know, they say we're entitled to our opinion, but we're not entitled to the facts or inaccurate statements about the law. And this bill has many of those up front. So you should be aware of that. And in addition to what Ms. Evans said, is, in a way, what we're doing is they're just kind of sprinkling a little bit of fairy dust on the problem. The threat from the 10,000 claims did not start with the tribes threatening that. I asked that question of a tribal attorney to represent my clients because I work in the water court, and there's only probably, I've asked my friends who do water court law, there's probably 10 to 15 attorneys who do most of the legal action in the water court. And so I asked the tribal attorney to tell me, because I wanted to protect my clients. I said, well, how many claims do you think you have? And they told me 10,000. So if anybody runs around saying that the tribe's threatening that, that's simply inaccurate. That is a number that came out because I questioned trying to find out how to best protect my clients' interests. And as Crystal Lee explained, when they file those claims at the water court, which they have to or lose them, just like my clients did in the 80s, you have to file or lose it if we don't get the compact passed, which the earlier legislatures provided for a compact commission to go out and negotiate these compacts. And I've done these issues across the West. It's much smarter to negotiate than to litigate them. And the other states where I've been, are looking to Montana as kind of being leaders on actually negotiating these compacts and getting them all settled rather than leaving it for the courts and decades in the future. So they've negotiated every compact and got it done besides this one. And now all of a sudden we hear all this stuff talk about fear mongering. The sky is going to fall if we pass this compact. It's ridiculous if you look at the many reasons why it should be done, but that hearing's for another day. And so the other thing that we haven't been told about is that on the heels of this compact, if it fails, we have bull trout up in that area. And I've done salmon wars, worked on behalf of agriculture in Washington State. And if the compact doesn't pass, then we have the United States Fish and Wildlife Service breathing down our neck to do what has to be done to look after, to meet the requirements for the Endangered Species Act in bull trout. There's no money in here for working on behalf of agriculture or Montana citizens to protect us in a Endangered Species Act public process. And I guarantee you we're much smarter as Montanan citizens to rely on the science that has gone into the compact because the federal government's willing to rest there and not have to get more water rights for in-stream flows if the compact doesn't pass. So that's totally missing. We've heard about the money. I actually ran on the back of one of my analyses, since this is something that I do day in, day out. I actually think, and this was a very conservative estimate, that per private attorneys for just 3 years of this, it would be $1.8 billion. I actually figured more than that. And my associate said, Hertha, you can't tell them that. They won't believe you. And I said, well, $1.8 billion is a lot of money, too. But the way I did that is you could do 10,000 claims. So let's say that that's how many they file. I put in 36 months, which is not a long battle in the water court. In water court battles, we do right now work in cases where the federal government's involved. And if there's a tribe involved, they have their individual counsel, but you also have the federal government who has to defend them. So I have to now defend against the United States government and the tribes council, and those are the cases that take forever because you have the long arm of the federal government and they don't have a budget. So I'm telling you that 36 months is very conservative to get one of these battles done. And then I did $2,500 to $5,000 a month. Again, a very conservative estimate when you pay for the attorney and the expert. So that's how I got to $1.8 billion. And in this bill, I think we have $2 million. So somebody could help me with the math. There's a big difference between $2 million and $1.8 billion. My associate said that I'm on the wrong side of this issue because if it doesn't pass, we're going to have to have a lot more attorneys in Montana. It will become the Montana Water Attorney Relief Act if the compact doesn't pass. And she says right now I'm messing with her kids' college fund by trying to get it passed. So I'm going against self-interest. And the last things I would point out to you is that I think that we already heard that it would roughly potentially cost $73 million for the water court, and we haven't actually got exact numbers from them. But the additional things they would have to do is we've never in Montana had to examine these types of rights. So we're going to have to go to the Montana Supreme Court and get rules developed on how we even examine these types of rights. Now, why is this just coming up at this time? You're going to hear about this more. But it's because this treaty, the treaty that was set aside the land for these tribes is a Stevens Treaty tribe, which means that they have hunting and fishing. And you'll hear that, well, in Montana, we've never recognized hunting and fishing rights. That's true, but they have in other states. They have in Washington, and they have in the Ninth Circuit. And when people hire me to litigate, and I say you can get better in settlement than you can get in court, it's a good time to settle, because you know who's going to win if we fight? I'm going to win. You're going to pay my bill. So this is the best case scenario for Montanans, and that's not a threat. That's just practical, real information. And the people who stood up and said that there's fear-mongering going on, they're the ones who are running around telling people that it would be a violation of the Constitution and different things, which I vehemently disagree with based on my 20 years of working in this type of law. So again, this is not a very good bill to solve the problem. If you want to solve the problem to help the Montana citizens to not have to pay for attorneys to protect, now remember, they're not being sued. Here's how it would work. My husband ranches, don't tell him I talked about him today, okay? He ranches in between Lenape and White Sulphur Springs. Well, that is where Lenape is, in between Martinsdale and White Sulphur Springs. What happens is he's at the mouth of the mussel shell. And if the tribe has to file their rights because of the deadline, they could file a right and say that they used to hunt and fish there. And now, unless my husband files an objection to that, it is a prima facie evidence that they have a right to an in-stream flow right on his water. So he doesn't get sued. He has to hire counsel to object to that until we win. And now how would I win in other cases? In other cases, I would argue about that the neighbor hadn't used his water rights. He's lost it for non-use or different things. I have an affidavit. I have aerial photos. That's what I use for evidence. In this case, how am I going to argue that the tribe didn't hunt and fish there time immemorial? We're going to be basing this all on archaeologists and stuff. So we're proving the burdens against my client to prove something that happened historically, which there may not be any good proof. The other thing that people haven't really thought about is that this also can be gained by other people in the system. If you're a downstream user in the mussel shell, you want my client to keep his water in the stream, or my husband and his neighbors, because they want that water downstream. So you're going to have other people who are going to game the system to try to keep water in the stream to get down to them. So there's a lot of unintended consequences, and I would suggest that we're much better off not opening the door for this type of argument in Montana, because the settlement is very reasonable and is much less than other tribes have gotten in other states. So please vote no on this bill and vote past the compact, and that's how you solve the problems for Montana citizens. Thank you.
Thank you. Further opponents?
Mr. Chairman, members of the committee, my name is Jay Bodner, B-O-D-N-E-R, representing the Montana Stock Grower Association. I'd like to just focus on one section of the bill, Section 4, dealing specifically with the fiscal note. If you look on page 5 of the fiscal note, it talks about, within the Public Defender's Office, number 2, water laws specialized area requiring expertise that's not typically found within the criminal defense. And I think that's a pretty accurate statement that I think all should really look at, where we're tasking with the Public Defender's Office with defending these rights. It's very specialized, very complicated claims that they're going to be looking at and examining and defending. And certainly it's not under their purview currently. So if we do task them with that, then they have to be able to defend those. So what do? They have the option then of contracting with other lawyers. Typically, as you look further earlier on in the fiscal note, they talk about if they do contracts with lawyers, it's typically at a much lower rate. It's I think they identified $62 an hour within the fiscal note. And I think when you look at these kind of specialized cases and this amount of expertise that would be needed, you'd have a very difficult time attracting lawyers, I think, at that rate. So I think that is certainly a concern for us. One of the other concerns is that we have as we looked at this is that some of these cases, if they go on for years and years and years, one of the challenges I think that you would face as a water user is, are you going to continue to have that continued representation? Are you going to have the same person that you're dealing with? Or are you going to have a new representation every year? And that's some of the things that I think would really certainly provide a lot of challenges for water users. So with that, we do stand in opposition. Thank you, Mr. Chairman.
Thank you. Further opponents?
Good morning, Mr. Chairman, members of the committee. My name is Chelsea Kramer, Cremer. Here today on behalf of the Montana Farm Bureau Federation and also in opposition to House Bill 427. In respect of your time and the diligence that you have given us all here this morning, I will echo all of the concerns that Ms. Evans raised in her testimony and say first and foremost that we wholeheartedly agree with the points that she raised and the concerns that she has. And what I would do in my testimony is simply point out one clause as a whereas statement on page 3, lines 11 through 13. Where it's referencing if the proposed Confederated Salish and Kootenai Tribes Water Compact does not pass the 64th legislature, water users on and off the Flathead Indian Reservation need assurances their water rights will be protected and defended by the state. That clause and several statements made by proponents already this morning signify that we know there exists a potential serious risk for water users throughout the state if the compact is not passed to defend their rights. It was based on a little bit of the sponsor's opening. Representative Brown mentioned that the people that will be affected by this are working families in Montana. They're working farming and ranching families, including my own, will be affected by this if the compact doesn't pass. And so I have real concerns with this piece of legislation, putting this kind of technical, specialized right that people like my family put a whole lot of faith in to make a livelihood for ourselves every year in the hands of the public defenders, who may, based on their expertise and simple infrastructure, may not have the ability to provide the sort of high-quality representation that will be needed with these technical issues. And so I would just offer to you today that, if this legislative body and the state wants to take a proactive role in protecting and defending water rights in Montana, that I think it's best that we focus on the negotiated agreement that is already before us and not House Bill 427. And I would ask for a no vote today. Thank you.
Thank you. Further opponents?
Mr. Chairman, members of the committee, for the record, I'm Mike Murphy, representing the Montana Water Resources Association. And we also go on record in opposition to House Bill 427 for all the reasons that you heard. I also wanted to indicate that the representative from the Montana Farmers Union couldn't be here and asked that I also indicate their opposition to House Bill 427 as well. And just one more specific point that I don't think has been commented on. Chelsea Kramer got close to this issue, but one note that I would like to make is that if we look at this from the standpoint of a fairness issue, the process here, potentially even the constitutionality issue of providing this assistance to one specific group of water users, those being those that are affected by the claims filed on behalf of the tribe. So again, Mr. Chairman, I'd raise that particular point, and with that, again, we stand in opposition to House Bill 427. Thank you.
Thank you. Further opponents?
Chairman Bennett, members of the committee, for the record, Nikki Zupanik with the ACLU of Montana. We're opposed to this bill because of the negative impact that it'll have on the Office of Public Defender's ability to meet its constitutionally mandated responsibilities to its criminal defendant clients. Frankly, our state has an abysmal track record when it comes to setting a reasonable scope of services for the Office of Public Defender and then to adequately fund those services. This bill reminds us of a similar situation that the legislature placed the office in at its inception, when at the last minute, the bill that created the office had an amendment added to it that required the Office of Public Defender to provide representation to parents in dependency and neglect cases. That last-minute addition was added without much regard to the primary purpose of the office, which is to provide for criminal representation, wasn't without regard to the primary expertise of the attorneys employed by the agency, again, for criminal cases, and nor with any regard to the financial and human resources necessary to carry out that charge. Right from the start, the office was woefully underfunded. And since then, the office has seen those dependency and neglect cases increase so dramatically that they have threatened to drown the office, and they put at risk the office's ability to meet its constitutionally mandated responsibilities to its other clients. We see that same type of mistake unfolding here under this bill. The fiscal note makes clear that the office is unable to adequately estimate the costs it would incur under this bill, meaning that this body would also be unable to adequately estimate a sufficient appropriation. And as best as I can tell, the fiscal note does not make clear how the office should handle the extensive and expensive expert fees and other litigation costs that are inherent in complex water law cases like these. Just across the hall, your colleagues on the Appropriations Committee are wrestling right now with the consequences of delayed and inadequate funding for this office. And all across the state, local criminal justice systems and clients are wrestling with the negative consequences of an underfunded and overburdened public defender system with backed up court dockets and overcrowded jails. We urge you not to add to those problems, and we urge you to vote no on this bill. Thank you.
Thank you. Further opponents?
Mr. Chairman and committee members, my name is John Carter. I'm an attorney with the Salish Kootenai tribes. I've represented the tribes for over 30 years now, primarily in the field of federal Indian Reserve and Aboriginal water rights, treaty rights, and intergovernmental communications. I'm also a faculty affiliated at the University of Montana and have taught classes in those subject matters as well. I'm kind of in the position of batting cleanup here, which is actually kind of fun, but it will cause me to juggle my notes a little bit, so if you'll give me some breathing room on that, I'd appreciate it. I will stick to the bill, by the way.
Very good.
But I would also... That, so. Okay. Before I get into the few points that weren't adequately covered and well covered by the opponents, I'd like to touch on a couple of the introductory notes by the supporters, if I could, and note that none of them are attorneys. Mr. O'Neill referenced a mandate from the state district court. That mandate had been subsequently overruled by the Montana Supreme Court about 3 or 4 months later, so it's of no merit. Secondly, Kate Vandermoor, an hydrologist, spoke to a federal lawsuit that I filed on water rights issues, asserting that it seeks to divest people of their land holdings. That is simply false. There is no provision in there that attempts to address any person of land holdings, period. I'm not sure which version of the complaint she supplied to you, but none of the versions of the complaint have anything to do with divestiture of land. So now comes the juggling, it's the cleanup part. There are many, many pages of preamble, many of which are pure speculation. This may violate the Montana Constitution, may violate the state constitution, may violate the U.S. Constitution, may violate public meeting laws, may violate the Water Use Act. There's lots and lots of mays, but there's only 2 wills that I could find in the preamble, and I would actually, one of them is on page 3, line 12 through 13, that this, if the compact is passed, it, quote, will result in the Confederated Salish Kootenai tribes and federal control of water on the reservation. I would ask the sponsor of the bill to demonstrate which portion of the compact that appears in. The other one is it will result in a water market and restrict uses on and off the reservation. And again, I would ask the sponsor to demonstrate which portion of the compact actually does that, which section, line, and verse. After that, I would like to note that there were 2 well-spoken provisions in the preambles. One, it was to create equal treatment for the Montana citizens, that's page 2, line 1, and equal treatment under the law, page 2, line 12. I'm going to make one statement and let it sit for a minute. Indian people are citizens of the state of Montana, too. They just are. So I think there's a little conflict in that preamble versus the reality of it. And equal treatment under the law. I don't see how it can be equal treatment under the law when one class of water rights claimant is treated remarkably different than another class of water rights claimant. There are 3 basic issues in this bill. And I kind of categorized them as direct, indirect, and destructive. The direct effect is that a certain number of people would have their water rights defenses paid for. For example, a Hollywood actor who owns a place on the Madison River, and the only claim against him, and he's not a Montana resident, but it's a state-based claim, the only claim against him is a tribal claim. He would have that paid for. His adjoining ranch neighbor, who is working hard trying to make a living and somehow is not subjected to a tribal claim, will have to defend all of those claims filed against him that are not tribal claims. That does not strike me as equal treatment under the law. People have spoken well on the nature, scope, and extent of water rights litigation. They go on for decades, so I won't touch on that. I would like to point out, though, that unlike every other aspect of funding appropriated for the public defenders, there are no eligibility criteria in this bill. It would allow any person, whether it be Ted Turner or the Koch brothers or anybody, to tap this fund and acquire it and have their private litigation expenses paid for by the taxpayers of the state of Montana. The bill, and I can't remember if anyone else spoke to it, but the bill appropriates or purports to appropriate $5 million, no matter how you cut it. If you're going to provide fair and equal representation, that isn't going to do it over the decades that this type of litigation could take. So those are some of the direct effects. The indirect effects are remarkably interesting to me. On section 6, page 6, lines 17 through 19, all of the litigation that we've spoken about is water court litigation. You'll note that on page 18, it does not speak to water courts, it just speaks to any court. It could be a maritime court, for that matter. You know, it's just not clear as to what court this bill actually applies to, and therefore persons could take this bill to pretty much any court they chose to take. But the even more interesting part is the word right after it. Court proceedings related to a water rights claim held by the Confederated Salish and Kootenai tribes. Let's say you're a ranch family, you're having a hard time making a go of it, life's tough, you end up getting a divorce, but you have a water rights claim that is subject to a tribal claim. Who does the public defender represent? Does he represent in the property distribution? Does he represent the husband or the wife? Or do you have to get two lawyers, one representing one representing the other? Same thing, land transaction. Water rights claim subject to a tribal claim. And the land transaction goes bad. That's related to a water rights claim of the tribes, as the statute speaks. Who does the public defender represent? Does he have to represent both? Does he have to go out and get independent counsel? It's a very, and I don't mean to slam the bill drafters, but it's a very poorly drafted bill in that it's so vague and ambiguous as to be so open-ended. Actually, I kind of do mean to slam the drafter, I guess, but sorry. The third point I will make is the destructive nature of this piece of legislation. It clearly treats water rights claimants disequally. In 1985, the Montana Supreme Court issued a case called State ex rel Greeley versus Confederated Salish and Kootenai tribes. In that case, the tribe sought to challenge the application of the Montana Water Use Act on the Flathead Indian Reservation. The court spent, and it's a wonderful opinion, by the way, for anyone who wants to really read up on Indian reserved, and in particular the Salish Kootenai tribes reserved and Aboriginal water rights. It just lays out a roadmap for the litigation that would come if the compact does not. But in any event, what the court said in 1985 was that the Water Use Act is adequate on its face. That means as it reads, it's okay. What the court explicitly did not rule on and held off ruling on was whether or not the Water Use Act was adequate as applied. And this bill would fall squarely into that adequacy as applied because you are treating water rights claimants disequally. And the Montana Supreme Court is profoundly clear in Greeley that water rights claimants, regardless of who they are, have to be treated equally across the boards. So I just think that this bill has sufficient flaws that it should probably not come out of committee. And I would be glad to answer any questions that any of the committee members would have. Thank you.
Thank you. Are there further opponents? Seeing none, are there informational witnesses?
Good morning, Mr. Chairman, members of the committee. I'm William Hooks, the Chief Public Defender for the state of Montana. I've heard my agency mentioned a few times this morning, and I'm available to answer any questions any of you might have. Thank you.
Thank you. Further informational witnesses?
Mr. Chair and members of the committee, my name is Melissa Hornbein, Hornbein, and I'm staff attorney for the Montana Reserved Water Rights Compact Commission, and I'm available to answer questions.
Thank you. Any further informational witnesses? Seeing none. Let's see, hands flashing already. Give me a moment to catch up. Questions from the committee, and just remember now, as I cautioned our proponents and opponents, questions to the bill. Representative Regier.
Thank you, Mr. Chairman. Question for Ms. Lund. Mr. Chairman, Ms. Lund, you talked about tribes' water rights coming from fishing and hunting rights. Wouldn't there be included an permanent easement then for the tribe across lands to get to those hunting and fishing?
Chairman Bennett, Representative Regnier, the courts that have allowed the tribes to have found that they have a right to in-stream flow for fish based on their fishing and hunting, the language, they have not given them an easement to go to follow that. So that would be beyond what the courts have done in other states who have recognized those in-stream flow rights.
Follow up.
Follow up.
Mr. Chairman, Ms. Lund, so fishing rights equate to water rights, but no access then?
So far, Chairman, Representative Regnier, so far the courts have not recognized an access right. They've used it mostly in the northwestern states, and they've mostly recognized that a fishing right, like for salmon, it allows for the right to have in-stream flow to make sure that there's at least enough habitat to have fish.
Thank you.
Thank you.
Representative Kelker.
Thank you, Mr. Chair. My question is for the bill sponsor, please. Mr. Chair and Representative Brown, I'm looking at the title of the bill, and I have circled on lines 9 and 10. This is the section of the title that talks about public defenders providing counsel, and I'm interested in knowing who gets the counsel. And it says in the title, to certain water rights claimants on or off the Flathead Indian Reservation. Then I looked in the definitions section of the bill to see if that population was defined, and I'm not finding it in the definitions. We have a definition for water rights defender, but I'm not sure what the universe is of folks who would be included in what it says in the title. People who have water rights claims on or off the Flathead Reservation. How big is that group? Who is that? Who's in and who's out?
Well, I mean, that will be, that who's in and who's out will be determined by who the tribe decides to file suit against. But
follow up.
Follow up. So the definition of those who could get a free defense paid for by the state is anyone who has water right claims and needs to file an objection.
it would be anyone who is being sued by the tribe.
Just one more follow-up, please.
Follow-up.
I'm asking the question on the basis of I'm understanding that the person with the claimant water right has to object to the lawsuit. Is that your interpretation?
Yeah, I would say yes. They would object to the lawsuit and then go through this process. Yeah.
Thank you. Thank you, Mr. Chair.
Thank you. Representative Cord, did you have a question? I don't want to ignore you again.
Mr. Chair, a question for the sponsor, please.
Mr. Chairman, Representative.
Mr. Chair, Mr. Brown, I'm just real curious why you chose to have the Office of Public Defender used instead of even the Department of Justice. But I'd just like to know why you put it there.
That was actually a recommendation to me from somebody from the AG's office because they had the system set up to handle the funds and to handle that kind of a transaction between different people. I am completely open to moving that if there was that's part of this process. It really is to find the best way to do this, and I'm completely open to that to move that to another location if that is what seems to work better. But that is the recommendation that I got, and so that's what we use. But I would be okay with moving that.
Just a quick follow-up.
Follow-up.
Were you aware that the Office of Public Defender is pretty much overworked and understaffed and not enough monies, and that they struggle and they really have no expertise in this area? Was that brought to your attention at any time?
Yes, it was, and part of that would be that the reason for the funding to them would be so they could either hire or contract the water rights defender, somebody who is versed in the water law.
Just one more quick one.
Follow-up.
Mr. Chair, so you looked at this as they're hiring just maybe one lawyer to handle all those cases. Is that correct?
Well, that would I am not an attorney, and I don't know how fast and quick all these claims are going to come. If you have 10,000 show up at one time, obviously they're going to need more than one attorney, right? But what they would, who and how many they would hire, that would be up to them.
Representative Burgley.
Yeah, Mr. Chair, question for Mrs. Lund. Mr. Chair, Mrs. Lund, you had made the comment that there were other states, or that this compact was asking for less water rights than had been given in other compacts in other states. And I think part of the debate here is the reasonableness of the contract or compact. Could you point out some of those cases and how this one would fall or be less than what was asked for and received in other compacts?
Chairman Bennett, Representative, I think that there have not been other compacts in other states for the most part because Montana is way ahead of the cutting edge as far as doing compacts to negotiate and settle these issues. What I said that has happened in other states is that the tribes with the Stevens type language have been able to secure in-stream flow rights for fish based on that language. So that's what's happened in other states. And I believe, based on what I witnessed in Washington working on behalf of agriculture on issues that had to do with the Endangered Species Act, tribes, and water for fish, that the amounts that are in this compact are less than what they could get if they go to court. So that would be the statement that I made.
Okay, I guess maybe a brief follow-up.
Follow-up.
So you wouldn't have any other cases that would deal, maybe like Washington dealing with salmon, or any cases like that where you could point to in-stream flow amounts that would be relative to this compact?
Now that's a different question, Chairman Bennett and Representative. In Washington State, they have had, they being the tribes on behalf of for fish, have had large success in causing large amounts of water to be left in the streams, in the tributaries, and in the main stem for fish, and that it was not, my clients' agriculture were not able to use that as they had in the past.
Okay, thank you.
Representative McConnell. And remember, folks, the compact hearing has been assigned to this committee, so you'll get all the answers you ever want in a while. So,
thank you, Mr. Chairman. A question for Mr. Carter. Mr. Carter, I'm sensing that there's a real confusion in this room about how a water right is asserted, and I know just enough to be dangerous with this stuff. So I would like to hear from an expert a very brief overview of how a water right is asserted.
Okay. The Montana Water Use Act set out a system. It realized, the Montana legislature realized that the historical approach to dealing with water rights just was not working because there were any different number of ways. You could post it, you could simply appropriate it, you could file for water. So in 1973, the state did a really good thing. It tried to consolidate and make a simple system of water rights claims. And what it said was that all existing uses as of 1973 shall be protected, and that any new uses after 1973 shall be obtained either through a permit or an exemption or something of that nature. So what the court said, with one big exception, and that's where tribes come in. So what the court said was that, excuse me, the legislature, I'm in the wrong forum. The legislature said all persons claiming a pre-1973 water right had to file a water rights claim that would establish point of diversion, place of use, priority date, general descriptions, volume, flow rate, et cetera, and importantly, priority date. And that those would all be thrown into this hopper called the DNRC and Water Court. It would be examined, sorted out, and then put into either a temporary preliminary or a preliminary decree. Each individual claimant is responsible for defending his own claim, without, not counting this bill. Each individual claimant, regardless of who they are, is responsible for defending against objections from other people. It goes on a priority system. What happens is the water court will eventually issue a decree that lists all the water rights, stack them by priority basis, and anyone who wants to object to their neighbor's claim has the right to do it. It's not a litigation like a lawsuit that was discussed earlier. It's a sort of a quasi-administrative process. One person does not go out and sue another person in a brand new district court case. It's all within the framework of the Water Use Act. What this state and every other state has looked at was how do you fit Indian reserved water rights into that framework, because they are uniquely different. And again, I would urge all of you to read the Montana Supreme Court Greeley opinion, because it's actually readable and it's very informative. Every other state in the nation has attempted to force Indian reserved and Aboriginal water rights into the square holes of the state system. These are round types of water rights, and the state system is rather regimented square holes. And sometimes they just don't fit. So in all of the states that have litigated those cases, some of those cases are still going on. I mean, the Colorado River's been in litigation since 1921 between states, tribes, the United States, and Mexico. What the Reserved Water Rights Compact, though, was created in 1979, probably the single smartest thing this state did to keep the cost of its water adjudications down. And what it said was that rather than litigate Indian reserved and Aboriginal and federal reserved, like Forest Service, and there are distinctions between those two classes of federal reserved right, rather than litigate those, we will create this body called the Reserved Water Rights Compact Commission to attempt to negotiate out Indian reserved and Aboriginal rights as well as Forest Service rights. And that as long as those negotiations are ongoing, the tribes would not be under that filing deadline for 1973 and older water rights. So this tribe and any other tribe that was in the process of negotiating a compact was absolved from the responsibility to file claims under state law. That provision of state law sunset during the last legislative session. And this compact, moving forward, if it does move forward, the tribes will not, as a matter of state law, necessarily have to file their claims. though for a protective standpoint, they will file them and move to stay them pending final outcome of the compact. If the compact does not pass the legislature, the tribes are under an obligation of state law. It's not a threat. It's the system that the state itself set up. There's no threat there. In fact, the threat would be against me, the tribe's attorney, if I didn't file claims. The threat would be for malpractice, which is a viable concern under that situation. But anyway, the point being, Montana law is the one that's dictating how this game plays out. And if the compact passes, the tribes don't have to file their claims. If the compact does pass, the tribes, excuse me, that's said the same thing. If the compact passes, the tribes are not necessarily obligated to, but will file claims and put them on stay pending final resolution. And if the compact does not pass, the tribes will file in earnest and move forward on those claims as the tribe sees fit. If I could, just for 1 second, correct a slight misstatement by one of the prior commentators, who my other...
Yeah, if somebody asks you the question, that's fine, but you've already had that time, so...
Follow up, Mr. Chairman?
Follow up.
To follow up with you, Mr. Carter, are there any rights, let's say that there's an assertion that needs to be made by the tribes. Are there any rights in this state that are senior to the tribes' rights?
Well, the tribes have two different classes of water right. One is a water right that comes about at the creation of the reservation and the treaty, which is July 16th, 1855. The other are those water rights that pre-existed the treaty, which are predominantly in-stream flow claims, hunting, fishing, gathering, plant materials, medicinal materials. Those Aboriginal claims have a priority date of time immemorial, so I can be willing to bet you that nobody else can beat that one. There might be a few old county, or not county, but territorial claims, but they would have to be filed within the state adjudication system and prove up that priority date. Otherwise, I think the tribe's pretty safe on the Aboriginal and pretty safe on the 1855 too.
Representative Manzella, did you have a question? And I just, committee, any of these questions you've asked for information, I expect you won't ask them during the compact hearing, so you've got that information. So.
Thank you, Mr. Chair. I'm afraid I have several questions, but I'm going to limit it to one for Dr. Cade at this time, please.
Thank you.
Mr. Chairman, Representative.
Thank you, Mr. Chairman. Dr. Cate, you had shared with us that there were 6,700 claims filed in Idaho, and it equated to 7 being approved. And that gives me some hope and optimism that we might be able to get through this. But can you explain or help us understand how Idaho's state law might compare to Montana's, and could we have a reasonable expectation that we could get out so easily, maybe?
Yes, not being an attorney, but familiar with the general adjudication, Idaho has an adjudication court, just like Montana has its water court. It's still required to use the McCarran Amendment to bring in the federal entities. And every claim that was filed and that would be filed here would be reviewed by, in Idaho, by the Idaho Department of Water Resources and also the Water Court and its specific staff. So they would be reviewed from the standpoint of purpose, priority date, reasonableness, assertiveness, and so forth. So that's what happened. And so I would expect the same thing to happen here on the issue of the 10,000 claims the tribes are claiming to look at. The water court would be obligated to look at what law applies, whether those claims are valid or not, where are they located. They'd have to look at what the Treaty of Hellgate covered, which really only refers to 2 pieces of land. They would have to bring in other treaties that basically excluded the Flathead tribes from their presence. So they would have to look at the law, including whether an Aboriginal right or a tribal reserved right is a federal reserved right, or if it's something different. The Nez Perce claims that went in, they claimed a lot of water. As I mentioned, the treaty language is still a Stevens Treaty, but the Nez Perce Treaty of 1863 actually had language that said the federal government reserves to the tribes fountains and springs off the reservation. There is no similar language in the Hellgate Treaty. So because those claims were asserted, they were actually rejected by the water court or by the adjudication court. The tribe then approached the state to negotiate those rights. They reached a settlement, and as I indicated, what those rights were. So, so generally, it would be, Western water law is pretty much the same in Western states. So, all courts are with these issues are required to use the McCarran Amendment. So I'm thinking that like I said, I could file a water right in Chicago doesn't mean that I'm going to get it. And so the court would have a chance to look at that, and again, under this bill, they would have those resources to do that. Thank you.
Representative Kelker, did you have one more question?
I have just one question. Mr. Chair, I have a question for the bill sponsor, please.
Mr. Chairman, Representative.
Representative Brown, I'm looking in the bill on page 3, and actually you'd have to go back to page 2 to see the beginning of the sentence. But there are, or the beginning of the topic, there are some figures mentioned on lines 1 and 2. This action ultimately impacts 303,000 people in 11 counties and 23,000 non-tribal members on the Flathead Indian Reservation. What I'm wondering is, what is the origin of these particular numbers? Because I'm still trying to figure out the universe of who would be affected by this bill in terms of free counsel.
Those numbers, I guess I could maybe refer that question and you could get a better answer possibly. But I believe those are in the population of the counties that are affected and the number of non-tribal members on the Flathead Reservation. But I would refer that to Mr. Virgil Jackson, if that is all right with him.
Do you want to re-refer that?
And he says that's correct, so.
Okay, thank you.
Thank you. Representative Hill, and then Representative Montfort.
Thanks a lot. Mr. Chair, members of the committee, I have a question for Mr. Carter. Thank you, Mr. Chair.
Representative Hill.
Thanks a lot. Mr. Carter, I was actually going to give you the opportunity, based on the question that Representative Regier asked you on access. I only took one semester of water law in law school, but there was something that Ms. Lund said regarding access that didn't strike me as my total understanding, although certainly you both have more experience, but I was going to allow you to respond to that if you...
Thank you. And with all due respect to Ms. Lund, there was a slight misstatement of fact or misstatement of law in that question. I believe the question was, does the treaty right impose an easement across the land? Is that roughly paraphrasing? There is a U.S. Supreme Court case from 1905 called United States versus Winans, interpreting a treaty with identical language to that of the Salish Kootenai tribes for the Yakima. And the fact situation was they were trying to fish the Yakima River. Non-Indians had acquired land off the reservation and were blocking access to those tribes attaining their usual and accustomed fishing spots. The U.S. Supreme Court ruled that the treaty imposes an easement upon their land as if written in the deed. I think that's almost a verbatim quote from the U.S. Supreme Court. So in fact, there is a clear access right to fish pursuant to Hellgate Treaty language, and the U.S. Supreme Court has upheld that. That was one of the first cases really dealing with treaty interpretation of Article 3.
Follow up.
Thanks a lot, Mr. Chairman. So just also on the bill, thanks for that, by the way, Mr. Carter.
Welcome.
I guess I did also, speaking of my one semester of water law, I actually also took one semester of what we called Indian law. I think it's called tribal law now, 12 years ago.
It's still Indian law.
Okay, Indian law, yeah. And I guess I wanted to give you an opportunity on the bill. The fiscal note talks about that this would examine, since you represent the Confederate Salish and Kootenai tribe, I wanted you to be able to respond to one of the proponents of this bill actually brought the phrase in, "bring it on."
Yes.
So I wanted you to be able to respond to that, because even in my one semester of understanding sovereignty and treaty rights, my understanding is that bringing it on, that the tribes would have a pretty solid claim to their rights. And would you just sort of like to respond to that?
Well, I would first respond to the bring it on, and the answer to that would be careful what you ask for. And the second answer would be the tribes have had a very successful litigation history, particularly against the Flathead Joint Board of Control, their principal protagonist on water rights. I believe the tally at the moment is about 29-1 tribes to Joint Board of Control on irrigation project specific water right cases in federal court all the way up to the U.S. Supreme Court. So while that sounds a bit like a brag, it's also a statistical fact, and that's where I would leave that.
Representative Montfort.
Thank you, Mr. Chairman. Question for Mr. Carter. Almost escaped.
Almost. Yes, Chairman?
Mr. Chairman, Mr. Carter, you cited the Winans case a few moments ago. And the Winans case involved an interpretation of a Stevens Treaty, is that correct?
Correct.
As I recall, the Winans case, in the Winans case, the Supreme Court said that there was a right of access to salmon in the Columbia River. Did the court hold in that case that right of access amounted to a water right?
The court did not hold it amounted to a water right. The court held it amounted to an easement upon the land as if written in the deed. It did not address water rights one bit.
Follow up, Mr. Chairman?
Follow up.
Are there any, Mr. Chairman, Mr. Carter, are there any cases subsequent to Winans that hold that Aboriginal rights arising from a Stevens Treaty result in a water right?
Yes.
Can you cite them for me?
I can. The Klamath litigation, which is ongoing in the state of Oregon, has explicitly upheld in-stream flows for fish in the name of the United States in trust for the tribe. That's an ongoing litigation. It's somewhat similar to Montana's, and it's sort of a mix.
And I'm sorry, let me stop you. I'm sorry to interrupt. Did that involve an on-reservation inflow in-stream right or an off-reservation?
Well, that's a very interesting question because the Klamath...
Gentlemen, just remember to go through the chair.
Sorry.
I know that you're accustomed in other arenas, but in this arena we go through the chair.
I apologize.
Thank you.
I apologize. Chair?
Representative Montfort.
Thank you, Mr. Chairman. And Mr. Carter, let me rephrase that question. Did the Klamath case, does that involve on-reservation in-stream flows or off-reservation in-stream flows?
Mr. Chairman, Representative, it is an interesting case because the Klamath are a Stevens Treaty tribe with nearly identical language to the Hellgate Treaty, but they were terminated by act of Congress in the 50s. So they do no longer have a reservation. But the court found even though the reservation was terminated, the treaty right retained to them the right for in-stream flows for fish, even though they no longer have a viable reservation. So I think if that happens for a tribe that has been terminated by Congress and has lost their reservation, I think it's a bit stronger case for a tribe that has not been terminated and has retained their reservation. Similarly, in Washington, there's a series of ultimate case called the Aquavia litigation involving the Yakimas, and that upheld off-reservation in-stream flow cases for tribes.
Follow up, Mr. Chairman?
One more follow-up.
Mr. Chairman, Mr. Carter, you stated in, looks like a federal filing from about a year ago, that the tribe has agreed to cede its Aboriginal title. Under the Hellgate Treaty, the tribe has ceded its Aboriginal land title to land west of the Continental Divide. Can you tell me what the legal basis is for the tribe to assert water rights east of the Continental Divide?
Mr. Chairman, Mr. Montfort, Representative, multiple. The cession was of title, not of usufructory rights such as hunting, fishing, and gathering, first off. If you look at Article 3 of the Hellgate Treaty, it speaks to both rights on reservation. In fact, it speaks to the exclusive right of the tribes to take fish on reservation and to hunt. And it also reserved, the tribes also reserved to themselves the right to hunt and fish off reservation in common with the citizens of the territory. The question that has come up earlier in these discussions was the length and expense of these cases. What the courts have held, including the Montana Supreme Court, is that the tribe's right to hunt off reservation is alive and well. And the question then becomes, how do you prove that? And the proof is through historians, anthropologists, and the tribal people themselves with their history and anthropology, and for that matter, archaeology. So it's a fact-bound question. Is this piece of land on the Mussel Shell actually usual and accustomed? Is this piece of land on the Montour actually usual and accustomed? Or the Yellowstone? It's a fact-bound question in every case. The tribes have spent approximately 20 years proving up both the anthropological and historical bases for their off-reservation claims. And that's where we're at.
Mr. Chairman, I do have more questions, but I will defer them to a later date. Thank
Very
you.
good.
Thank you, Mr.
We've
Carter.
wandered a long way from the bill. So, seeing no further questions, Representative Brown, please close on your bill.
Mr. Chairman, members of the committee, I will start by saying I am not an attorney. And I don't think our state should be run by attorneys, quite frankly, with all due respect to all those attorneys that are in the legislature. But you know, we need you, but that's not the total voice of the people. If we were nothing but attorneys, we would probably not move even a little slower than we do now. But anyway, enough on the lighter side. You know, we did hear a lot, and I do appreciate the chairman's leeway in everybody's testimony today. We have heard a lot. We have learned a lot about not just House Bill 427, but the compact in general. The one thought, there's two thoughts that I really want to leave you with. We're not talking about a neighbor arguing with a neighbor over water rights. We are talking about a sovereign nation coming against an individual. I believe that if Canada was to move in to take away your rights, I believe the state should step up to protect you. And I see this the very same way. And there should be a viable alternative for them to do that, which I believe 427 gives us that alternative. And also, you know, there are some constitutional issues here, and the reason really that it may violate the Constitution, because I believe that will be litigated at some point in time, whether the compact does violate the Constitution. I took an oath to defend the Constitution, and until it is proved otherwise that it is not a violation of the Constitution, I will defend that. And so, in closing, I just would thank you all for a great hearing, and just remember, this is your neighbor coming up against somebody that they can't fight against. Thank you.
Thank you, Representative Brown. This closes the hearing on House Bill 427.